Start. Every assignment of and every charge on and every agreement to assign or charge any pension payable to any officer or soldier of Her Majesty's forces or any pension payable to any such officer or to any person in respect of any military service shall except so far as the same is made in pursuance of a royal warrant for the benefit of the family of the person entitled thereto, or as may be authorized by any act lot the time being in force be void. Stop. In considering whether a receiver of a retired officer's pension ought to be appointed, not only the language but the object of section 141 of the Army Act Stop must be looked to, and the object of the section would, in my opinion, be defeated and not advanced if a receiver were appointed. Stop. Passage. It is beyond dispute that the object of the legislature was to secure for officers who had served their country a provision which would keep them from want and would enable them to retain a respectable social position. Stop. I do not see how this object could be effected unless those pensions were made absolutely inalienable. Stop. Preventing not only the person himself assigning his interest in the pension but also preventing the pension being seized or attached under a garnishee order or by an execution or other process of law. Stop. Unless protection is given to this extent, the object which the legislature had in view is frustrated and a strange anomaly would exist. Stop. A person with a pension would not be able to utilize his pension to pay a debt beforehand, but immediately his creditor had obtained judgment might be deprived of his pension or attachment, equitable execution, or some other legal process. Stop. It is impossible to suppose that the legislature could have intended such an anomaly. Stop. Section 51 of the Civil Procedure Code, no doubt recognizing 5 modes of execution of a decree, and one of them is the appointment of a receiver. Stop. Instead of executing the decree by attachment and sale, the court may appoint a receiver, but this can only be in a case where a receiver can be appointed. Stop. The provident fund money is exempt from attachment and is inalienable. Stop. Normally, no execution can lie against such a sum. Stop. The learned judges in the court below rested their view on the authority of the decision of the Privy Council in Rajendra Narayan Singh versus